Welcome, everybody. Welcome to today's episode of the Law of Self-Defense, slightly unprepared edition. Sorry, folks. Hopefully everyone can hear me okay. Let's check out the live streaming where it should be live streaming. Looks like it's here and working on YouTube, and you never really know with Rumble, and Twitter is working just fine. I don't know about Rumble. I'm getting pretty... Oh, there it goes. Finally, kicks in. All right. So it looks like we're streaming everywhere we need to be streaming today. Come on in, folks. Come on in. Make yourselves comfortable. We have an interesting case to talk about today. I'm in the process... Oh, of course. I guess I should introduce myself. Representing Law of Self-Defense, I am attorney Andrew Branca. Thank you. Thank you very much. So pleased to be here for this open access show, meaning that we're making it publicly available in this live stream. Of course, it's streaming to our Law of Self-Defense members. More about that in a moment. But also on YouTube, on Rumble, and on Twitter, open to the public to help us grow the Law of Self-Defense community. And I've been in the... we have kind of an ongoing process here at Law of Self-Defense. Of course, we produce books and educational courses, contents, materials, do legal consulting on use of force cases all over the country, meaning in all 50 states, the District of Columbia, and all U.S. territories. And so we maintain the laws, the use of force laws, all relevant laws for all those 50 states. And of course, periodically, well, on an ongoing basis, really, we're updating those. And I was just updating California again. And I was reminded of a case that's not new, but that reminds us that it's extremely dangerous to rely on the apparent plain English reading of a statute. And I know that most of you are doing exactly that. Most of you, for example, when you got a concealed carry permit, you took a concealed carry course someplace, and some firearms instructor at the front of the class got to the mandated legal portion of that course of instruction and read you a bunch of statutory language about self-defense, maybe about gun laws too. And that was supposed to be helpful to you. Probably it wasn't. And even if it was, it can be incredibly dangerous to simply presume that a normal, plain English reading of a statute is something that you can rely on to protect you from criminal liability. That may sound insane to many of you, but that's the truth. And that's what we're going to dig in today, is an example of that from the great state of California. So with that intro out of the way and people getting settled in, hopefully everyone's getting settled in, I will launch into things. Here we go. All right, folks. So I did mention at the beginning that this is an open access show. It's not limited to our Law of Self-Defense members. More than half our content is limited to Law of Self-Defense members. In fact, just yesterday, we did a really fun show on the recent bus shooting in Charlotte, North Carolina. Spent an hour reviewing all the video, talking about all the relevant laws of that particular shooting, with a particular emphasis on that moment when the bus driver steps outside of the bus and fires a parting shot at Ceballos, the unlawful aggressor here, who got himself into a gunfight with this surprisingly armed bus driver. That show was a lot of fun, but it was available only to Law of Self-Defense members, and still is available only to Law of Self-Defense members. The good news is that membership in Law of Self-Defense is incredibly cheap. In fact, you can try it out for just 99 cents, folks. 99 cents gets you a 2-week trial to Law of Self-Defense and all our members-only content. All of it. That's thousands of hours of videos, blog posts, podcasts, normally available only to Law of Self-Defense members. You get unlimited access during that 2-week period. just as if you'd been a paying member all along, for 99 cents. If you don't like it, just let us know. We'll cancel your trial membership. We'll give you 200% of your money back, which granted is only $1.98, but we didn't ask for much going in, did we? So 99 cents gets you 2 weeks. And if you stay a member after that, folks, it's still dirt cheap. It's only about 30 cents a day. It's less than $10 a month to get typically 2 members only shows a week, sometimes 3 members only shows a week, that only you have access to as a law self-defense member. 30 cents, folks. Honestly, if you're sitting here watching these hour and a half long shows that I do, and you don't think they're worth 30 cents, I don't know what you're spending your time on. It doesn't make any sense to me. But in any case, you can try out this law of self-defense membership for 2 weeks for 99 cents at lawofselfdefense.com/trial. And I'll keep that at the bottom of the screen here where my name normally goes. So I would urge you to consider that. We're doing a show tomorrow, members only. It's going to involve a case out of my local area, out of Denver, happened a couple of years ago, in which the police fired 30 rounds at a woman, many of them when she's laying on the ground. She'd already been dropped by rounds. And it was found to be completely lawful. Completely lawful. So we have the body-worn camera video of that shooting event, and we have the local prosecutor's report explaining their decision to conclude that the use of force by the officers, even 30 rounds, was perfectly lawful under those circumstances. But again, that will be a members-only show. Most of the shows we do that have video of violence, especially if people are being killed, is members-only content, folks, because there's no point to me putting it on YouTube. I just get demonetized when I do that. So tomorrow's show, woman gets shot 30 times, local prosecutor. By the way, it's Denver. It's not like it's a conservative prosecutor, right? Local prosecutor decides the cops involved were perfectly lawful in firing 30 rounds at a woman, many of them when she's laying on the ground. And we have the body-worn camera footage for that, as well as her report. All right. So with that out of the way, let's get to the substance of today. And that is the general idea that it's extremely dangerous to rely on the apparent plain English reading of a statute. And first, I'll describe that in kind of an academic sense, and then we'll dive into an actual case out of California that illustrates this. But it comes up all the time. Oh, by the way, Shane reminds me, folks, we are this close to having 50,000 subscribers, 49,238 subscribers. If you're not yet a subscriber to Law Self-Defense on YouTube, please hit that subscribe button. Make it happen. There's no reason not to. I'd love to hit 50,000. You don't get anything special for doing that, I guess. But it would be nice, a nice milestone for Law Self-Defense on the YouTube channels. Hit that thumbs up button. Leave a comment, even if it's just your city and state. That helps fool the algorithm as well. And do all the same things on YouTube. Of course, the most helpful thing you could possibly do for Law Self-Defense is, screw YouTube, become a Law Self-Defense member. Again, 30 cents a day. We're not really taking super chats anymore. I mean, if you just want to give us money on YouTube or Rumble, I guess I'll take it. The functionality is still active, but we're not answering questions on those platforms anymore. So if you want your questions answered, your comments answered, we're only taking those from the comment section in the live stream chat from Law Self-Defense members in the member dashboard. So the engagement really is only going to be with Law Self-Defense members. Another great reason to, come on, 30 cents a day, 99 cents to try it out for 2 weeks at lawofselfdefense.com/trial. So the idea that it's extremely dangerous to rely on the plain English reading of a statute. Why is that? Well, folks, because statutes by themselves, what are they? Of course, they're laws passed by the legislature, right? Signed by the governor, or maybe pocket passed. In some states, the governor is not required to sign a law. If he lets it sit long enough, it just becomes law. Or it might be a law passed over a governor's veto. But essentially, it's the legislature branch deciding there ought to be a law about something. So they pass a statute. That statute does absolutely nothing. Not a damn thing. It's just words written on a piece of paper. Zero effect in the real world until that statute is interpreted and applied by an actual court to actual parties before the court. In our context, of course, we're typically talking about criminal cases. So that criminal statute has no impact in the real world until a judge in a criminal trial interprets and applies that statute to the parties, the state and the defense before him in that trial. That's when a statute has real world effect. Even then, it only has an effect limited to those particular parties. A trial judge's decisions about how the law applies is not binding on any other court. It's not even binding on that judge if he decides to change his mind in another court proceeding the next day with essentially similar facts. Those court interpretations of statutes are not binding on anybody until and unless they are interpreted by the appellate courts. In most states, there'd be a mid-level kind of a court of appeals between the trial court and the highest level court in the state, which is typically called the Supreme Court, but not always. New York State, for example, is weird. It calls New York State's Supreme Court, the highest court in the state, is actually called the Court of Appeals. Most states, the Court of Appeals is the mid-level courts. So you have to watch out for that kind of thing. But until it's an appellate court interpreting a law, there is no precedential value. It's not controlling on anybody else because that precedential authority flows downhill, right? If you imagine a pyramid with the state Supreme Court at the top, its decisions on how the law should be applied are controlling on every other court in the state because the authority flows downhill from them. The mid-level appellate courts, typically their decisions are binding on the trial courts within their district, within their area, but not necessarily in other trial courts. We see this commonly in the federal level, right? Where there's federal courts of appeals. There's different ones, different areas around the country where they're assigned, the Ninth Circuit, the Fifth Circuit, and so forth. And they have a ruling, and typically their rulings, like we have a very favorable ruling out of the Fifth Circuit right now on arm braces, the ATF arm brace rule. And strictly speaking, it probably only applies within the Fifth Circuit. They did do a weird thing with that ruling where they said it applies to the Fifth Circuit only, and also to the members of one of the plaintiffs, the Firearms Policy Coalition, which is suing over this ATF rule. So a lot of people just became members of FPC, even if they don't live in the 5th District. By the way, FPC just modified its membership rules to say that you were effectively a member as of last June 2022, if you become a member no later than today. So if you have an arm brace and you'd like the theoretical protection of this injunction the Fifth Circuit just ordered against ATF on the arm brace rule, I think it's $20 or $30 to become a member of FPC, but today would be the last day to do that. So Firearms Policy Coalition, I have no relationship with them. I'm just aware that this is going on. I do happen to be a member, but I don't benefit in any way if you become a member. Okay, so statutes have no effect in the real world until they're interpreted and applied by courts. And here's the thing. It's not unusual for courts to read language into and out of statutes. So interpret a statute as if it included words that were not there, or interpret a statute as if words that are there don't have any meaning and should just be ignored. And that law, that interpretation of the statute is just as valid law as the statute itself. In fact, it's more controlling than the apparent plain English reading of the statute because it defines what the statute really means. So 2 ways for laws to be created, right? Let's set aside constitutional matters. There's bills become laws by the legislature. That's one way, statutory law. The second way is case law. These interpretations and decisions by the appellate courts. And that's just as valid as law created by the legislature. In fact, it defines what the legislature statutes actually mean. So the statutes passed by the legislature don't mean what the legislature meant them to mean, or hoped they would mean, or wished they would mean, or intended them to mean. Those statutes mean what the courts say they mean, period. So if you're reading statutory law, and it seems plain enough to you, and you constrain your conduct within the boundaries of that statutory law, you may or may not be acting lawfully. because the actual legal boundaries are not what the statute appears to say. The actual legal boundaries are what the courts that interpret that statute say they are. So you could be within the plain English reading of a statute and be outside the legal scope of that statute per the interpretation of the courts. So if all you've done is read the statutes and you haven't looked at the court decisions that interpret and apply those statutes, you don't really know what those statutes mean. You just don't. And we have an example of this from California. So the kind of the background here is that there was a California homeowner, and he'd had not a very wealthy person, didn't have a lot of stuff, didn't have a lot of property, had a home, and people were breaking into his home when he wasn't there, typically. And a couple of youths were using burglary tools to break into his home, and one of them got shot in the face. And the question was this use of defensive force at the time this occurred? This was in the early 1970s. Was that use of force lawful? The use of deadly defensive force to shoot that attempted burglar in the face, who was making an unlawful and forcible entry into the home, or at least attempting to do so. And the homeowner's defense was essentially, well, I don't even have to argue that I was defending my home. I can just argue self-defense, because the California self-defense statute, its plain English reading, says I'm allowed to use deadly defensive force under these circumstances when someone's making a surprise, a surreptitious entry into my home. Guess what? That didn't work out well for him. Now, there is another very interesting wrinkle to this case. It's a separate set of legal issues from what I just discussed. The homeowner's justification for the use of force. And so I don't want you to confuse the two. It's very common for people to look at a case that involves distinct issues and blend them all together, conflate them all together. And it leads to poor legal understanding and legal analysis. So it's important you understand this first issue I raised, that the plain English reading of the statute allegedly justified the homeowner's use of deadly force. That's one issue. A second set of issues that we'll talk about, just because they're so interesting from a historical context, is that the homeowner didn't actually fire the shot himself. He set a trap, what might be called a spring trap, where someone opens a window or opens a door, there's a string that goes to the trigger of a firearm. In this case, that firearm was triggered by the burglars while the homeowner was away from home. Now, the defendant's argument here is that none of that matters, because I'm allowed to do anything remotely that I would have been allowed to do had I been personally present. So if it would have been lawful for me to fire the shot in person, and I'm claiming it is under the plain English language of the homicide statute and California law, justified homicide, then it's lawful for me to do it by a remote device. But two separate arguments, right? One is, was it lawful at all to use deadly defensive force in those circumstances under then existing California law? And the other is, if it is lawful to fire the shot yourself, would it also be lawful to do it with a remote device, with a trap, a booby trap, essentially? So let's take a look. But the real point of today's show is not the spring trap thing. I'm just going to cover that because it's the appellate court that looked at this case did kind of a broad historical review of American and Old English law on traps. So I thought it would be interesting for everybody. But the real point of today's show is that relying on the plain English reading of a statute can be dangerous, because the courts can interpret things in and out of the statutes. And if you don't know how the courts actually interpret that statute, you don't know what it means. So, and again, I knew this, but I read a lot of law, folks. So you can't keep everything in your head all the time. And my recollection of this was refreshed when I was updating our California law just this week, and came across this case again. So let's start here with the relevant California statute that the defendant in this case, and I believe he was charged with, the person shot in the face was not killed. The youth shot in the face was not killed, but I believe the homeowner was charged with aggravated assault with a deadly weapon. Obviously a very serious felony. In most states, 20 years in prison with the gun sentencing enhancement. So it may as well be a manslaughter charge. And he's raising the legal defense of self-defense under California's justified homicide statute, which is right here. Let me pull that up. Here we go. Let's see if I can do it like this and still have it be, whoops, what I want it to do. Okay, that should still be kind of legible. All right, so California Penal Code 197, justifiable homicide by other persons. Homicide, it says it's also justifiable because the immediate preceding statute, 196, is justifiable homicide by law enforcement. So just pretend we just read that section and now we're talking about justifiable homicide by other persons, not law enforcement. And it reads, homicide is also justifiable when committed by any person in any of the following cases. When resisting any attempt to murder any person or to commit a felony or to do some great bodily injury upon any person. So you can kill when you're resisting someone committing a felony. Or when committed, the homicide is committed in defense of habitation against one who manifestly intends or endeavors by violence or surprise to commit a felony. That was the defendant's, the homeowner's defense here, not the first paragraph, because he was not personally present, right? So he was not personally resisting a felony. His booby trap was resisting the felony, but not him. What he's arguing is the use of force by the booby trap, which would have been lawful if I had done it personally, was committed in defense of my habitation against the person who was manifestly intending or endeavoring by surprise, surreptitiously, to commit a felony, the burglary of the property. And based on the plain English reading of the statute, that's not a bad argument. I mean, it really was uncontested that these youths were committing a burglary of the home. They had burglar's tools. They were breaking things to get in for the purpose of stealing. I mean, it was the only credible. They weren't getting in there to rescue their cat who got into the house by accident. They were a little ambiguous, ambivalent sometimes in their own statements and testimony about, well, maybe we weren't sure we were going to steal something, but come on. They were there to commit a burglary, which is a felony. And they were doing it by surprise. They were sneaking in. And the statute says a homicide is justifiable when committed in defense of habitation against one who intends or endeavors by surprise to commit a felony. Seems straightforward enough. And that was the legal defense raised by this homeowner, raised by this defendant when he was charged. And let's see how that worked for him. By the way, I mentioned statutes. I mentioned case law as both being equally robust, real sources of law. There are also, of course, jury instructions. Now, jury instructions are not properly sources of law. They don't create law. Legislatures do in the form of statutes, and appellate courts do in the form of case law decisions. Jury instructions are not really sources of law. But what they are, and this makes them very helpful, is they tend to be an amalgamation, a combination of the statutory language and how the appellate courts want that language applied. Because the jury instructions are essentially created by the appellate courts, typically the Supreme Court of the state. So a little history here. In the old days, well before I was practicing law, but in the old days, the Abraham Lincoln days of practicing law, jury instructions were essentially drafted anew for each trial. Now, of course, there was a long history of similar cases with similar jury instructions. So it wasn't like they were literally starting from nothing. But in the course of, say, a criminal trial in the 1800s, the court would get to a part of the proceedings where they'd say, all right, defense and state, I need whatever you think are the correct versions of jury instructions. And the judge would read them, and then he'd come up with some combination of those that he thought accurately reflected the law in this case as the jury should be instructed on it. But they did that for every case. And so you ended up with quite a bit of variance in jury instructions from case to case, including very similar cases on the facts. And this was thought to result in injustice. Defendants who were similarly situated, charged with similar crimes and similar facts, were getting different jury instructions, and therefore different legal outcomes, different verdicts. So one by one, the states all began to create what are typically referred to as standard or pattern jury instructions, from which the trial courts are supposed to choose their instructions from this list approved by the state Supreme Court and not make up their own. In fact, once the state Supreme Court has said this is the list of standard, pattern, approved jury instructions, the quickest way for a trial court to get reversed is to deviate from what the state Supreme Court told them to do. After all, the trial court, if it's reversed by the appellate courts, right? And the appellate courts are the ones who wrote the jury instructions they want used. So you're being literally insubordinate if you're not following their orders. They're your bosses if you're a trial court judge. So we have these pattern jury instructions, and typically the state Supreme Court would pull together a large group of legal experts. So academic experts from law schools, prominent defense attorneys, prominent prosecutors, maybe retired judges, and these folks would work together for a period of months, looking at the statutes, looking at the case law, and coming up with these standardized jury instructions that are a combination of the statutory language and how the appellate courts have said they want it applied. And it's standard. That's what every trial court has to choose the appropriate jury instructions from those that are approved. So that makes jury instructions very helpful for lay people because it is this combination of the statutes and the case law, and even more importantly, the jury instructions, unlike statutes and case law, are written in plain English. Statutes, well, they're written by the legislature, and let's face it, we don't typically send our very best to the legislature, right? So statutes are often not well written. Case law, court decisions, it is the definition of legalese. These are arguments written down by lawyers, judges, for lawyers, right? So court decisions can be difficult to work through if you're not yourself a trained legal expert. But jury instructions are intended for non-legal experts. They're jury instructions that will be read to a jury. Presumptively, no particular expertise in the law, so they have to be written in plain English, and they typically are. So jury instructions, combination of the statutory law and how the courts want that law applied to real people in real cases, and it's written in plain English, which is great. And as a bonus, it's very common for jury instructions to have the portion of the instruction that's literally read to the jury, and then also have something that's not read to the jury, but is intended to help the trial judge and help the lawyers really understand how the jury instruction should be applied. And these are typically called bench notes. So when I was reviewing California law, I was reviewing California jury instructions, came across the jury instruction for the use of force in defense of a dwelling, and it had a very interesting bench note that pointed out exactly what we're here to discuss today, that in fact, the plain English reading of the statute was not the appropriate interpretation of that statute. So let's jump into that jury instruction. And that's this one. California, Cal Criminal Jury Instruction 506, justifiable homicide in the context of defending against harm to person within home or on property. Now, remember when we looked at the statute here, that the statute says homicide is justifiable when committed in defense of habitation against one who manifestly endeavors by violence or surprise. And that's what this defendant in this case is relying on, this whole surprise issue. Well, they were entering surreptitiously by surprise. Well, when we look at the jury instruction, it reads, the defendant's not guilty of murder or whatever the charge is in any of the following cases. When resisting any attempt to murder any person or to do some great bodily injury. Okay, that's fine. That's straight up self-defense. But more important to our case, when committed in defense of habitation against one who manifestly intends or endeavors by violence or surprise. So we still have, back here to the jury instruction. The defendant's not guilty of murder or whatever the charge might be if the defendant reasonably believed that he was defending a home against someone who intended to violently, riotously, or tumultuously enter the home to commit an act of violence. Well, what happened to surprise? Surprise, the word surprise has disappeared from this jury instruction. But it's still in the statute. I mean, this is the current version of the statute, and this was how the statute existed at the time of this case. It says right there, by surprise. But when you look at the jury instruction, surprise doesn't appear anywhere in the relevant, the parallel jury instruction on defending against harm to person within a home or on property. So, why is that? Well, we scroll down and we get to the bench notes. Here are the bench notes. This is not read to the jury. This is language that's intended to guide the trial judge and the prosecutor and the defense in properly understanding the jury instruction. And it points out, and this would have been written by the academics who developed, the academics working with other legal professionals who developed these jury instructions, who looked at the statutory language, looked at how the case law wanted that language applied, and noted that there was a disconnect. So they're pointing out the disconnect. And these academics tell us that Penal Code Section 197, which is the justifiable homicide section, subdivision 2, provides that defensive habitation may be used to resist someone who intends or endeavors by violence or surprise to commit a felony. And remember, that's what this defendant's relying on, that this youth who got shot in the face, he was intending to commit a felony by surprise, by surreptitiously breaking into my home to commit a burglary. However, the academics tell us, in People versus Ceballos probably, this is a 1974 California, I believe it's a Supreme Court case. Let me take a look. Yep, California Supreme Court case. The California Supreme Court held that the felony feared must be some atrocious crime attempted to be committed by force. Forcible and atrocious crimes are those crimes whose character and manner reasonably create a fear of death or serious bodily harm. Ceballos specifically held that burglaries which do not reasonably create a fear of great bodily harm are not sufficient cause for exaction of human life. Thus, although the statute refers to defensive habitation, Ceballos requires that a person be at risk of great bodily harm or an atrocious felony in order to justify the homicide. The jury instruction has been drafted accordingly to reflect the case law and not merely copy what the statute says. So what Ceballos effectively did was take out surprise. They read surprise out of that statute. Surprise is not enough. There has to be some threat of death or serious bodily injury to persons before the California courts will allow you to use justified homicide as a justification for taking a human life or using deadly force upon another person. So force readily capable of causing death, or in this case, serious bodily injury, a gunshot to the face. And helpfully, we have that course case linked here. So let's go take a look at the actual court decision. People versus Ceballos, California Supreme Court, 1974. Now, the court actually covers our issue of interest, this reinterpretation of the statute, after it talks about the booby trap issue. So what I'm going to do is go past the booby trap issue, and we'll come back to it after we get to the heart of the matter. So People versus Ceballos, and by the way, if you've never looked at a court decision, an appellate court decision, this is typically how they're structured. You have the parties, the people, of course, being the state. There are most states, it would be state versus defendant, whatever the defendant's name is. I think there's 4 states that do people, New York, Colorado, Illinois, and California. Instead of using state versus defendant, it's people versus defendant, if I'm recalling that correctly. People versus Ceballos. Then you have the case citation, which you can think of as kind of the license plate, the unique identifier for this decision. The state, the court within the state, the Supreme Court, and the year. Of course, they list the parties, Don Luis Ceballos, the counsel for the parties. Lots of counsel here, both for the defense and for the state, especially for the state, because it's a state Supreme Court case, so it's a big deal. So lots of people get involved. The judges, unanimous view of the court. So 1, 2, 3, 4, 5, 6, 7 judges here on this California Supreme Court decision, unanimous decision. The opinion. So Don Ceballos, spoiler, they like to give spoilers at the beginning often, was found guilty by a jury at trial of assault with a deadly weapon. The sentence was suspended. He was placed on probation. He appeals from the judgment, contending that his conduct was not unlawful because the alleged victim was attempting to commit burglary when hit by a trap gun mounted in the garage of defendant's dwelling, and that the court committed error in instructing the jury. We've concluded that the former argument lacks merit and that the court did not commit prejudicial error in instructing the jury, and that the judgment should be affirmed. So some facts of the case. Defendant lived in a home in San Anselmo. The regular living quarters were above the garage, but defendant sometimes slept in the garage and had about $2,500 worth of property there. In March 1970, some tools were stolen from his house. In May 1970, he noticed the lock in his garage doors was bent and pry marks were on one of the doors. The next day, he mounted a loaded .22 caliber pistol in the garage. The pistol was aimed at the center of the garage doors and was connected by a wire to one of the doors so that the pistol would discharge if the door was open several inches. The damage to the defendant's lock had been done by a 16-year-old boy named Stephen and a 15-year-old boy named Robert on the afternoon of May 15th, 3 days after this trap was set up. The boys returned 3 days after the last effort to break in. The boys returned to his home while he was away. Neither was armed with a gun or a knife. After looking in the windows and seeing no one, Stephen succeeded in removing the lock on the garage door with a crowbar. Deadly weapon, a crowbar? Depends on the manner of use, right? Sure can be. And as he pulled the door outward, he was hit in the face with a bullet from the pistol. Pretty lucky shot for a fixed pistol pointed at the width of a garage door. Stephen, the burglar who was shot in the face, testified. He intended to go into the garage for some musical equipment because he had a debt to pay to a friend. His way of paying would be to take the defendant's property and sell it, and use the proceeds to pay the debt. Oh, he wasn't going to steal for sure, necessarily. He was just there to look around. And getting in, I don't know if I would have actually stolen. That sound credible to anybody? The defendant, testifying in his own behalf, admitted having set up the trap gun. He stated that after noticing the pry marks on the garage door, on May 12th, he felt he should set up some kind of a trap, something to keep the burglar out of my home. When asked why he was trying to keep the burglar out, what kind of question is that? He replied, because somebody was trying to steal my property and I don't want to come home some night and have the thief in there. Usually a thief is pretty desperate and they just pick up a weapon if they don't have one and do the best I can. When asked by the police shortly after the shooting why he assembled the trap gun, the defendant stated that he didn't have much and he wanted to protect what he did have. So explicitly using the gun in defense of property. The jury found the defendant guilty of assault with a deadly weapon. An assault is an unlawful attempt coupled with the present ability to commit a violent injury on the person of another. So in most states, we would call what happened here a battery. There are a couple of states that use the term assault more broadly than the traditional meaning. New York's another one. But normally, a battery is when you cause an injury to someone in a way that's arguably a crime. There's contact, unwanted contact or injury. An assault is usually not that. An assault is when you put someone in fear of an imminent unlawful harm. So you put them in fear of an imminent battery. So you run up to someone with your fist raised as if you're going to punch them and they see you coming and they're frightened of being struck. That's an assault. When you strike them, that's a battery. Of course, you could run up behind them. They never saw you coming and then you punch them. That would be a battery with no assault. They were never in fear of the blow because they never saw it coming. When you have both the fear and the strike, you have assault and battery. But here, California is using the term assault to indicate what I would call a battery. The shot to the face. Defendant contends that Had he been present, he would have been justified in shooting Stephen, since Stephen was attempting to commit burglary. By the way, this nomenclature that the court's using here is this is not black letter law, folks. This is just the observation of a lawyer who's been practicing for 32 years. Courts are sending messages when they use this type of language. And what I mean specifically is when they reference the defendant, they're not referencing him by name. They're not calling him Don. They're calling him defendant. But when they reference the burglar who was breaking into Don's home with a crowbar, which obviously would have been a deadly weapon of opportunity had the burglar unexpectedly encountered Don inside his own home, when they refer to the burglar armed with a deadly weapon, they refer to him as Stephen. Defendant and Stephen, not burglar. Defendant contends that had he been present, he would have been justified in shooting Stephen, since Stephen was attempting to commit burglary. He says the defendant had a right to do indirectly what he could have done directly. That's a justification for the trap gun. And that therefore any attempt by him to commit a violent injury upon Stephen was not unlawful and hence not an assault. And the lawfulness would be that had he been present, he would have been using a deadly force to stop this felony being committed by surprise on his habitation. The state argues that the rule is unsound. The case cited by the defendant is unsound, should be distinguished here, not apply here. That as a matter of law, a trap gun constitutes excessive force, and that in any event, the circumstances were not in fact such as to warrant the use of deadly force. So again, two distinct arguments here, folks. So keep them clear. One is the argument about the trap gun. Can you use a trap gun at all, ever? Any trap readily capable of causing deadly force? That's one question. The second question is, would deadly force have been permissible even if it had been used by the defendant here, the homeowner? Two separate issues. Had the homeowner been present and had the gun in his own hand and fired it. So here we have all the historical disquisition of the spring trap. Let's see. But I'm going to skip to the second argument. Would the use of deadly force have been justified here had the homeowner been present with the gun in his own hand and fired the shot himself? After the court discusses the whole trap issue. The court continues, furthermore, even if that rule were applied here, even if we pretended that the trap was lawful, the booby trap, the defendant was not justified in shooting Stephen. Penal Code Section 197 provides homicide is justifiable when resisting any attempt to murder any person or to commit a felony or do some great bodily harm, that's Section 1, or when committed in defense of habitation against one who manifestly intends or endeavors by violence or surprise to commit a felony. Since a homicide is justifiable under the circumstances specified in 197, an attempt to commit a violent injury upon another under these circumstances is justifiable. That's the defense argument, essentially. By the terms of subdivision 1 of Section 197, that's just the self-defense argument. We're not really interested in that. Let's see. We're interested in subsection 2. And the court continues. But subdivision 2 of that section is also likewise limited. But also, they just argued subdivision 1 doesn't apply. I'm fine with that. But it says section 2 is likewise limited. The term violence or surprise in subdivision 2 is found in common law authorities. And whatever may have been the very early common law, the rule developed at common law since then that killing or use of deadly force to prevent a felony was justified only if the offense was a forcible and atrocious crime. So, folks, if you imagine historically, most felonies were crimes that inherently involved a threat of force of violence. But today we have lots of felonies that have no threat of force of violence. Right? There's drug possession felonies. You write a bad check over a certain dollar amount, it's a felony. There's no threat of violence to another person in those cases. You may want to live in a world where you can kill someone for writing a bad check over a certain dollar amount. But and this is not just California. The courts throughout the U.S. have adopted the position over decades that when a statute says you can use deadly force to prevent a felony, it means, even if it doesn't say this explicitly, it means a forcible felony, even if the word forcible is not in there. So the appellate courts read the word forcible into the statute. So if the statute says you can use deadly force to prevent a felony, and you claim the underlying felony was writing a bad check, and that fits within the plain English reading of the statute, too bad for you. Because the plain English reading of the statute is not what the statute appears to say. It's what the courts say that statute says. And the courts say that felony, even though the statute doesn't include the word forcible, has to be a forcible felony before deadly defensive force is permissible. Here, the court's doing something slightly different. It's reading out the word surprise, or it's interpreting the word surprise in a way that would only apply to a forcible attack. It continues, surprise here, and here's where they're doing it, means an unexpected attack, which includes force and violence. And the word thus appears redundant. Folks, it's a fundamental rule of statutory interpretation that the presumption is that the words, the individual words in a statute, are not redundant. That each word has a specific meaning, or it would not be included. And here, the California Supreme Court is just deciding on its own initiative that they don't need to follow the normal rules of statutory interpretation. If we look back at 197, we can see that includes when committed in defense of habitation against one who manifestly endeavors by violence or surprise. Why did the legislature include the word surprise if they meant violence, which they've already referenced? Standard statutory interpretation would say, no, surprise must mean something different than violence. Or they're just being stupidly repetitive. They're being redundant. But that's California Supreme Court says, no, we decide that force and violence and surprise means the same thing. Thus, the word appears redundant. We're going to read surprise out of the statute as if it doesn't exist. Examples of forcible and atrocious crimes are things like murder, mayhem, rape, and robbery. Well, of course, burglary has been included in the list of such crimes. However, in view of the wide scope of burglary under the penal code, as compared with the common law definition of that offense, in our opinion, it cannot be said that under all circumstances, burglary under the law constitutes a forcible and atrocious crime. Okay? Now, the old common law definition was burglary of a dwelling, a structure in which people resided, spent time. Of course, now we apply burglary to things like tool sheds, for example. Many states have very broad burglary statutes. And here what the California court is saying is, since we've opened up the scope of burglary to mean almost anything, we're not going to presume that a burglary of a tool shed in which no one would ever be living. Well, today, lots of people in California live in tool sheds, but in a normal world, no one would ever be living in a tool shed. We're not going to treat that kind of burglary of a tool shed as if it were the same kind of atrocious crime that a burglary of a home would be, where people would be expected to live. Let's see. In the instant case, the asserted burglary did not threaten death or serious bodily harm, since no one but Stephen and Robert were then on the premises. A defendant is not protected from liability merely by the fact that the intruder's conduct is such as would justify the defendant, were he present, in believing that the intrusion threatened death or serious bodily injury. Right. So the moment the court reads out surprise and requires violence, and it's undisputed that the defendant was not physically present and therefore could not have been threatened with violence, there goes his defense. We thus conclude the defendant was not justified under the penal code in shooting Stephen to prevent him from committing burglary. Our conclusion is in accord with dictum, indicating that there may be no privilege to use a deadly mechanical device to prevent a burglary of a dwelling when no one is present. That's back to the spring trap argument. In support of his position that he would have been present, that had he been present, he would have been justified in shooting Stephen, the defendant cites a number of cases. These look like civil cases. Obviously, this California Supreme Court is going to distinguish that because they found against the defendant. So they obviously didn't buy his argument. Says, no, we just don't like his arguments. We don't like the cases he's citing to support his position. Let's see. We recognize, this court says, we recognize that our position regarding justification for killing under the penal code, California Penal Code, differs from the position of the restatement of torts. Torts is personal liability. That's civil suits, folks. And there's legal textbooks written on how torts should be pursued and defended against. And they come up with things that are much like jury instructions. And the court says, well, we realize this interpretation we're choosing here today to apply to this defendant is different than they do it in civil courts. But we're just going to ignore that as well. Let's see. And then he makes some other arguments, incidental arguments that just kind of a word salad set of arguments. If my main argument doesn't work, please try these other arguments, and the Supreme Court doesn't buy any of them. So the judgment of guilt on the aggravated assault with the weapon charge is affirmed. Now, at least the defendant wasn't sentenced any time, but it's still a felony conviction, so he's a convicted felon. No more guns for him. Let's get back. So that's the main point of today's show, folks. The plain English reading of a statute may not be what the statute actually means. Now, today, in 2023, the California justified homicide statute still includes the word surprise. So it's not as if when a word is read out of a statute by the appellate courts so that the word doesn't exist for legal purposes, it's not like it's automatically removed from the statute. The word surprise is still in the statute. So someone in California reading that section 197 of the penal code, justified homicide, will see the word statute in there today, in the current version of that statute, and may rely on it. And unless they looked at how the courts actually apply that statute, and a pretty good way to do that is, of course, to take a look at the jury instructions, because they often explain this kind of thing. And then you can look at the court decision as we did here today. If someone relied on that surprise term in the justified homicide statute in California, they'd be screwed. By the way, you can also get trapped on this with no way to know. I mean, look at this defendant. At the time this defendant was convicted, obviously this California Supreme Court decision is an appeal of his conviction, so it didn't exist at the time of his trial. This defendant didn't have the benefit of knowing that the California Supreme Court was going to read surprise out of the statute because they hadn't done it yet. To him, this interpretation applies retroactively. Too bad. You can't pass a retroactive statute, but it's in the nature of appellate review of statutory language that they decided applied to that defendant properly in the past. Unfortunate. We have an imperfect legal system, folks, but that's the way it works. All right, so with the dangers of relying on the plain English reading of a statute pointed out and the importance of looking not just at the statutory language, but how the courts interpret and apply that statute, let's turn now to the historically interesting part of this decision, which is the spring trap issue. Completely distinct. Let's see. The issue. So spring traps they're often called spring traps, trap guns, booby traps, and they're traps that would be triggered by someone unaware of the trap. And we can divide them into traps that are capable of inflicting non-deadly force, something like a pepper spray dispenser. So you trip a wire and you get sprayed in the face with pepper spray. Those are distinguished from deadly force, booby traps or spring traps. We're only really interested here in the deadly force ones. The deadly force ones would typically would trigger a firearm discharge is the most common way they're done. So when we say trap gun, we don't mean a gun that shoots trap and skeet, for example. It's a gun that's part of a booby trap. So let's hear what this court has to say about the law of booby traps, deadly force booby traps. The issue of criminal liability under statutes such as the Penal Code, where the instrument employed is a trap gun or other deadly mechanical device. This could also be like a pit with stakes at the bottom, right? Or a bomb or anything you might think of. Appears to be one of first impression in this state. So California had not considered this issue before. But in other jurisdictions, courts have considered the question of criminal and civil liability for death and injuries inflicted by such devices. At common law in England, it was held that a trespasser, having knowledge that there are spring guns in a wood, cannot maintain an action, a civil suit, for injury received in consequence of his actually stepping on the wire of such a gun. So this might, for example, be a poacher. We're talking in old England. Before we were America, the homeowner, the landowner, the baron or whatever, would get tired of the poachers and would set out booby traps, deadly force booby traps. And if a poacher tripped one of them, being aware, he'd been notified, announcements had been made throughout the village. Don't go into the baron's woods anymore, poachers, because he set booby traps in there. You get injured by the booby trap, you can't bring a civil suit against the baron. But that case aroused such a protest in England that it was abrogated 7 years later by a statute which made it a misdemeanor to set spring guns with intent to inflict grievous bodily injury. So you can't set deadly force booby traps, deadly force being death or serious bodily injury. But it excluded from that prohibition the operation of a spring gun set between sunset and sunrise in a dwelling house for the protection of the home. So you couldn't set traps in the woods, deadly force booby traps. You couldn't set deadly force booby traps in your home during the daytime, but you were still allowed to do it in your home at night to protect the home. Interesting. In the United States, courts have concluded that a person may be held criminally liable under statutes prescribing homicides and shooting with intent to injure, or civilly liable if he sets upon his premises a deadly mechanical device and that device kills or injures another. However, an exception to the rule that there may be criminal and civil liability for death or injuries caused by such a device has been recognized, where the intrusion is, in fact, such that the person, were he present, would be justified in taking the life or inflicting the bodily harm with his own hands, which was basically this defendant's argument. Had I been present, it would have been lawful, and therefore the booby trap was lawful. The phrase, were he present, does not hypothesize the actual presence of the person, but is used in setting forth in an indirect manner the principle that a person may do indirectly that which he is privileged to do directly. Again, this was this defendant's argument. Allowing persons at their own risk to employ deadly mechanical devices, by their own risk, they mean you could set off your own trap yourself, right? Allowing persons at their own risk to employ deadly mechanical devices imperils the lives of children, firemen, and policemen acting within the scope of their employment and others. So you're not home, smoke is coming out of your house, the firemen kick in the door to put the fire out, and they set off the booby trap, right? That kind of thing. You're not home, and your neighbor reports your home's been burglarized, and the cops show up and enter the home to investigate the burglary, and they trip the booby trap. Where the actor is present, there's always the possibility he will realize that deadly force is not necessary. So a fireman kicks in your door because there's smoke in your house, you don't shoot the fireman, right? But the booby trap wouldn't know that. But deadly mechanical devices are without mercy or discretion. Such devices are silent instrumentalities of death. They deal death and destruction to the innocent as well as the criminal intruder without the slightest warning. The taking of human life or infliction of great bodily injury by such means is brutally savage and inhuman. The court continues, it seems clear that the use of such devices should not be encouraged. Moreover, whatever may be thought in torts, civil cases, the foregoing rule setting forth an exception and liability for death or injuries inflicted by such devices is inappropriate in penal law, criminal law, for it is obvious that it does not prescribe a workable standard of conduct. Liability depends upon fortuitous results. We therefore decline to adopt that rule in criminal cases. So, no deadly force booby traps under California law. at least for criminal cases. And you have to presume this court would apply that standard to a civil case too, but they don't have a civil case here before it. All right, folks. So this happened in 1974. Today in California, does this mean had you been physically present, you can't shoot someone breaking into your home? Well, since 1974, California's adopted some new laws. One is California Statute 198.5. Now, remember, justified homicide was 197. There's presumably a 198. Let me take a quick look. I probably have that right here. So 197 is justifiable homicide. 198 is bare fear not to justify killing. It has to be a reasonable fear. It can't be a irrational fear that's part of objective reasonableness. And then it's 198.5. And if the decimal suggests to you that they squeezed this in between the existing 198 and 199, that's typically why that happens. And so they have this statute 198.5, which was when? Do I have a history? So this was added 1984, 10 years after the Supreme Court decision. So it seems likely that the populace of California were rather alarmed by this People versus Ceballos decision. Wait, someone's breaking into my house with a crowbar? Into my house with a crowbar. And even if I were personally present, I wouldn't be justified in using deadly force to defend myself or my home? That doesn't seem right, the residents of California might have thought. So they pressure their legislature to pass a statute to correct this arguably poor decision by the California Supreme Court. And that statute, 10 years after the court's decision, probably is this one, 198.5, presumption in favor of one who uses deadly force against an intruder. And it reads, any person using force intended or likely to cause death or great bodily injury within his or her residence shall be presumed to have held a reasonable fear of imminent peril of death or great bodily injury to themselves, family, or a member of the household when that force is used against another person who unlawfully and forcibly enters or has unlawfully and forcibly entered the residence, and the person using the defensive force knew or had reason to believe that an unlawful and forcible entry occurred. So this is a legal presumption law. We've talked about these many times. When you're using force in defense of personal property, generally speaking, you can only use non-deadly force, Texas being the one exception. But there are often special provisions for the use of deadly force in defense of highly defensible property. And the most common form of those is to create a legal presumption that the defender, when facing an unlawful, forcible intruder, had a reasonable fear of imminent deadly force harm at the hands of that intruder. The 5 elements of self-defense, of course, are innocence, imminence, proportionality, avoidance, and reasonableness. These are the building blocks of any justification for the use of force against another person. You can get this little cheat sheet for free, folks, at lawofselfdefense.com/elements. And what the presumption does is give you most of the elements of self-defense. So think about the elements, imminence, proportionality, and reasonableness. That's 3 of the 5, right? Right here, you can see them on this side of the cheat sheet. Well, look at this. Look at the statute. It's presumed that the defender had a reasonable fear of imminent death or great bodily injury, which is proportionality. That's deadly force. That's 3 of the 5 elements required to be justified in the use of deadly defensive force. A 4th element is avoidance, whether or not there's a legal duty to retreat. First of all, California is a stand your ground state. But second of all, you're in your home. The castle doctrine relieves you of any existing duty to retreat. That's 4 of the 5 elements of self-defense given to you in this scenario. The only one left is the element of innocence, that you were not the initial physical aggressor in the fight. But innocence is kind of baked into the cake, isn't it? When you're in your home and someone's forcibly and unlawfully entering your home. Every jury knows what that would feel like. So these legal presumptions are great, and this is what Statute 198.5 gives you. And of course, it's also reflected in a jury instruction, Cal Crim 3477. The law presumes this is what the jury would be instructed. This would be read to the jury. The law presumes the defendant reasonably feared imminent death or great bodily injury to himself or to a member of his household if an intruder unlawfully and forcibly entered or was entering the defendant's home. And of course, these other conditions as well. All right. So that is the bulk of what I had to share with all of you today. I'll take, now I'll look to the questions presented by the Law Self-Defense membership, folks. Moving forward, we're only taking questions and addressing comments from the Law Self-Defense members. As a default, I'm not going to read every super chat or every Rumble rant anymore. I might take a quick look at those and just see if there's anything particularly interesting to address. But if you're submitting super chats or Rumble rants just to give me money, that's fine. I've got a costly German motorcycle habit. But if you're doing it to get your questions or comments answered, stop. Just become a Law Self-Defense member. You can do it for 99 cents right here, lawselfdefense.com/trial, and then get your questions and comments addressed for free as a Law Self-Defense member. That's the way to do this. All right, so let me get to the member questions now. Good morning from all the Law Self-Defense members in the member chat. Welcome, everybody, all the usual suspects, and a lot of new members. We've been picking up a lot of new members. That's always very gratifying. Tony D asks, where is the line of legislating from the bench? Where is the line? That's a good question. What's the limit on the court's ability to do that? Traditionally, it's simply been at the discretion of the court. I mean, the courts can simply come up with word salad arguments for why a statute should be interpreted and applied in a way that's different than the plain English reading of the statute. They're not supposed to do that, but they do it all the time. Now, they know that ultimately they could piss off the legislature enough that the legislature will pass a responsive statute, like appears to have happened here. At one point in Massachusetts, the Massachusetts Supreme Court read out of the law the Castle Doctrine, reimposed a legal duty to retreat in your home. And that induced the Massachusetts legislature, that was also the 1970s, by the way, that induced the Massachusetts legislature to pass one of the two self-defense statutes that the Commonwealth of Massachusetts has. The self-defense law, defense of others law in Massachusetts, is not in statute. It's in court decisions only, which makes it very difficult to learn for lay people. But one self-defense statute they do have basically reversed the Massachusetts Supreme Court and reapplied the Castle Doctrine in the state, relieving you of a legal duty to retreat. So sometimes when the courts go too far in the eyes of the public, the eyes of the legislature can respond with a statutory fix. Of course, I can tell you that in the 50 years since the Massachusetts legislature passed their Castle Doctrine statute to essentially overturn the Massachusetts Supreme Court decision, who do you think gets to interpret that new statute over a 50-year period? Yep, the same Massachusetts Supreme Court you just reversed. You think they'll interpret that statute in as narrow a way as possible? They sure did. In Massachusetts, most states, the Castle Doctrine, you being relieved of an otherwise existing duty to retreat before you can use deadly force in self-defense, the benefit of the Castle Doctrine, being relieved of that legal duty to retreat, applies to you if you are within the four walls of your home while you're defending yourself, of course, but also if you're within the curtilage of the home, outside the four walls, but close enough to the home that you're still within the scope of the home that's part of the normal day-to-day use of the home. That's called curtilage. In Massachusetts, the Massachusetts Supreme Court read away curtilage. In Massachusetts, if you have 1 foot outside your front door, outside the four walls of your home, no Castle Doctrine privilege for you. So yeah, there's often this tension between the legislature and the courts. Happens all the time. And there is no clear line. Jeffrey asks, when a new law goes into effect, what do trial judges do for jury instructions? Once standardized, can someone appeal a conviction if he believes the provisional instructions were faulty? You can always appeal a conviction on the grounds that the jury instructions were wrong, were bad, were defective in some way. Now, If you're arguing that the pattern jury instructions were defective, you got a big problem because those were the ones approved by the state Supreme Court. You're going to convince them their own jury instructions were wrong. But in that case, you must have at least have objected to the jury instruction to preserve the issue for appeal. If it's not a standard jury instruction, but something that the trial court had to kind of cobble together, maybe there wasn't a good jury instruction on it, maybe there's a new statute and there's no pattern jury instruction yet, because they don't create these automatically. These are created every few years. The pattern jury instructions may be created, updated. So you can have a new statute that doesn't have a jury instruction yet, in which case the trial judge would do it the old-fashioned way. He'd say, all right, state, defense, I need a jury instruction. Each of you give me one, what you think would be your preferred version that reflects the law of this statute, for which is brand new, for which there's little case law yet, and I'll put something together that I decide is an accurate reflection of the statute based on what you've provided me. That could be so wrong and is not pre-approved by the state Supreme Court, right? So that's very subject to appeal by a defendant if he's convicted as a result. Let's see. Dave says, could the state legislatures, when writing state statutes, be influenced by the politics of the day? Which is why so many times in so many cases the statute seems vague or ambiguous to enable variation favorable towards political biases. Well, normally the legislature is not being intentionally ambiguous and hoping the court's political biases will control the day in a way the legislature likes. Normally, the legislature is politically biased, and so they bake their political bias into the cake. For example, I was just reviewing Colorado law. I have to. By the way, there won't be a show next Monday, folks. I actually have to be in court next Monday. But there's a Colorado statute on what force is permissible by law enforcement officers. And as you may know, chokeholds by cops has become a very politicized form of force, disfavored politically. And so years ago, the Colorado legislature, responding to political pressure, had put into Colorado statute that chokeholds were not permitted by police unless they were facing a deadly force threat. So essentially just defining chokeholds as deadly force, deadly defensive force, which is silly, of course, because a properly applied carotid chokehold is not deadly force when properly used, any more than a baton is deadly force if it's used for compliance purposes. A carotid choke that you apply for compliance purposes and the suspect submits or transiently loses consciousness, I'd argue that's not a use of deadly force at all. But the Colorado legislature said every chokehold is deadly force, therefore you can only use it if you're facing a deadly force threat. I think that takes a really valuable tool away from law enforcement. I think a carotid chokehold should be permissible if they're facing even just a non-deadly force threat. But anyway, the Colorado legislature, responding to political pressure, said no chokeholds unless a deadly force threat. Well, you know what they did within the last couple of years? They changed that statute, responding again to political pressures, and now it's illegal for police in Colorado to use a chokehold under any conditions. That person that you would be choking is about to set off a suicide vest. Can't choke him. Can't put a carotid choke on him. It's amazing. But yes, of course, legislatures respond to political pressure. But typically what they do is not leave things ambiguous so the courts might rule in their favor. They bake their political bias into the statute. Let's see. Jim Buchanan asks, is there a service providing information on judges' interpretations of the law, their actions on key issues? As a voter, we're provided zero information when electing judges. Yeah, I'm not aware, folks. I tend to know that kind of thing where I'm working cases because I have to deal with the judges. So you get a sense for how they make decisions. But the normal public doesn't have that kind of information. And where would it come from? The lawyers won't do it. The defense lawyers and the prosecutors are not going to do it because they have to, be before that judge. So they're certainly not going to say anything negative about the judge. If anything, they bend over backwards to say only positive things about judges for obvious reasons. Let's see. Richard says, does the removal of surprise from the effective removal from the California justified homicide statute violate the U.S. Constitution provision against laws that are ambiguous? Well, no, because this court will say it's not ambiguous. You just have to know how to interpret it the right way, our way. Let's see. Wendy says, I was talking to someone last week who says South Dakota has rescinded the laws prescribing deadly force in defense of property. I haven't had time to research this. Well, that's the first time I'm hearing of it, Wendy. But I will take a look. And if it's true, I'll do a show on it. Let's see. Now I lost my little, here we go. By the way, South Dakota is free to do that. Every state is free to do that. Every state, as a matter of public policy, could pass a statute that says you can now use deadly force in defense of personal property. Texas does it. Any state can do it. They just don't want to. Let's see. No, we haven't moved. In fact, you just missed a train, and the train horn just went by a few minutes ago, but I guess the microphone didn't pick it up. But we are moving. Unfortunately, not anytime soon. I have another year on this lease, but we will not be renewing the lease on this building. I think I'll probably pick up an office maybe closer to Denver. All right, those are all the substantive questions that I had. So at this point, folks, I will go ahead and begin to wrap this show up. Again, I would urge you, become a law self-defense member. You can try it out for 2 weeks for 99 cents. 99 cents, folks. 200% money back guarantee, negative risk opportunity. For that 2 weeks, you have unlimited access to all our members-only content. The membership's not limited in any way. And if you stay a member, and virtually everybody does, it's still only 30 cents a day, folks. It's less than $10 a month to be a law self-defense member. Double the amount of law self-defense, legal analysis, insight, expertise, jokes, train horns you get here at Law Self-Defense. More than half our content each week is for members only. Now, try it out for 2 weeks, lawselfdefense.com/trial, and never pay a super chat or Rumble rant again to get your questions answered. Oh, I did have somebody leave one comment on YouTube, and I wanted to address it. It's not really about the case, but Aquamarin, Swiss, 5 Swiss francs. I was surprised when I went to Switzerland on a motorcycle trip 10 or 12 years ago. I had forgotten that they don't use the euro. In fact, they have border controls, and the customs may stop you at the border. They didn't stop me. They wave a lot of cars by, and then they still have their own money. So good for them. He notes, tip jar from Switzerland, where target shooting with the SIG 550 is a national sport. 135,000 participants at the largest competition this weekend. Yeah, that's amazing. I've shot the SIG 550, and I am a big fan of that rifle. It is a lot of fun to shoot for sure. When I was teaching for SIG Sauer in New Hampshire, I had the opportunity to shoot it, and it was great fun. Highly recommended. I mean, listen, in America, we live in an age where you can pick up a reasonably decent AR for like $500. Holy cow! What a country! It's amazing. I love it. All right, so that's it. Our Law Self-Defense trial membership at lawselfdefense.com/trial. And with that out of the way, folks, I would just remind all of you that if you carry a gun, if you own a gun, if you learn self-defense for any reason, so that you're hard to kill. That's why I carry a gun. That's why I do BJJ. In fact, I'm going to roll on the mats right after the show. If you do any of that, so that you're hard to kill, so that your family is hard to kill, which is why I do it. So I'm hard to kill, so my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.